Okay. I wanted to ask you one other question, Ms. Willingham, and then I'll get criminal history information from Ms. Jackson, although you just went away. Ms. Willingham, are you there? Uh-oh. Well, I'll ask you, Ms. Wood. We have a prosecutor in here, so we're not flying blind. I bet Ms. Willingham will jump back on. But my question is,
Judge, I don't know what happened. Some link popped up and then it closed my screen.
Okay, you're back.
Yes.
Great. My question for you was, you had mentioned 12 months probation, but it was served 60 days, and we've got only one misdemeanor. And so my plan was to structure the sentence 12 months to serve X months with a balance on probation, because we can't really, I know he served, it looks like 80 something days already. But if you wanted the sentencing document, and I do want it to reflect a custodial term and not just probation in the face of what was a violent encounter, then it would be a little less than 12 months probation. So I just wanted to make sure that's how you understood it.
Yes, Judge.
Okay. All right. And your video is back on. So I'll add you. There you are. You're back. Okay. Ms. Jackson, good morning. Could you please share with me what criminal history information you have for Mr. Ballard?
Yes, Your Honor. He has 25 cycles. The last arrest was June the 29th, 2023 in Fulton County for driving while license suspended or revoked. There was no disposition for that arrest. He does have misdemeanor convictions, if you'd like to hear those, Your Honor.
Just how maybe like the most recent two?
Okay. The last one was in 2015 for theft by shoplifting, and prior to that, there was one in 2011 for driving while license suspended or revoked. Nothing in addition, Your Honor.
Thank you. All right. So, Mr. Ballard, it sounds like you've managed to stay out of felony trouble, and you'll continue to do that through this plea. Also sounds like maybe you're not supposed to be driving until you get that driver's license situation fixed. That's just going to bring you more woe. Ms. Wood, what do you want to share about Mr. Ballard?
Thank you, Judge. He's 64 years old. He's a lifelong Atlanta resident. He has one adult son. He does have a high school education and 2 years of college. He is retired. He did industrial cleaning services for a living. We appreciate the state's offer in this case, and we ask that you accept it. I think it's appropriate for this case. He has no issue staying away, and he actually also requested that. He has been in custody since September the 28th, so he has done the 84 days already, Judge.
Okay. Mr. Ballard, how long had you known Ms. Cleveland when you all had this encounter in September?
Only for about 6 months, Judge.
How did you meet her?
Through a friend.
Okay. Okay. I'm not going to get real personal. I just was curious how long you and Ms. Cleveland had been talking, how long you've known each other. So it sounds like it was fairly brief. So if you need to leave her alone, that's not going to be real complicated.
No problem at all, sir.
Okay. Where will you be living when you get out?
Back with my mother.
Okay. How old's your mom?
84.
Okay. Is she in good health?
Very good health.
Excellent. Okay. So you'll stay with her. Is her house anywhere near where Ms. Cleveland stays?
No, ma'am. No, sir. No, sir.
Good. Okay. Well, that's going to make this easier for you. Do you have any questions for me?
No, sir.
All right. Well, I find there's a factual basis for your plea, Mr. Ballard, and that your plea is knowing and voluntary. Knowing means you've understood everything, and it sounds like you have. You told me you have no questions. And voluntary means no one's forcing you to enter this plea. You've decided it's the right way forward for you. Do you agree with that?
Yes, sir.
Okay. Mr. Ballard, is it all right if someone from my staff electronically signs the indictment indicating your guilty plea to the misdemeanor?
That'll be fine, sir.
Ms. Wood?
Okay,
Yes,
my
Judge.
judge, my lawyer.
Oh, yes. His question, Ms. Wood, is it okay? Do you think it's okay that we sign electronically for Mr. Ballard?
Yes, Mr. Ballard, it's totally fine.
Well, I give you my permission.
All right, and Ms. Wood, we can sign for you, and Ms. Willingham, can we sign for you?
Yes, Your Honor.
Okay, we'll do that. So I'll accept your plea to the reduced count of family violence battery. I will sentence you, Mr. Ballard, to a term of 12 months to serve 3 months with the balance probated. So you'll be on misdemeanor probation for 9 months. You will get reporting instructions probably through Ms. Wood, but you're going to need to meet with the misdemeanor probation folks at least once in person. And then it may be that it's phone in after that. I don't know. I don't control that, but you'll certainly need to stay in contact with probation. If they cannot find you, they bring me a warrant, and that's a waste of your time.
Yes, sir.
Several special conditions of your probation. Number 1, no contact with Ms. Cleveland. Don't call her, don't write her, don't roll by her place. You shouldn't be rolling anywhere unless it's on a bicycle anyway. Get your license.
I guess.
No contact with Ms. Cleveland. I'm also going to have you submit to a drug and alcohol abuse evaluation. And you just sit down with a specialist who's going to ask you about what you eat and drink and put in your system. And if that person recommends any treatment, maybe going to AA meetings or who knows what, that treatment will become part of your probation. So if that person says you got to go to counseling, you got to go. Okay. Similarly, you're going to meet with a doctor or someone, and probation is going to help you find this person who's going to give you a mental health evaluation to make sure that if there's any kind of meetings you should be having or medicine you should be taking to help you stay stable, that you'll do that. And whatever treatment is recommended, whether it's a medicine or it's counseling, that will also be part of your probation. Finally, I know it sounds like a lot, but most of this is designed to keep you as a 64-year-old gentleman out of harm's way. So it's good stuff. The last is that you're going to need to complete what's called a family violence intervention program, which is a series of classes where you're going to be meeting with folks who've been dealing with some of the same things you've been dealing with to come up with a good set of tools so that if you do meet a new young lady in your life and you get a little frustrated with things, it doesn't end up like it did just a few months ago in September of 2023. Ms. Willingham, did I cover all the conditions you had requested?
Yes, Your Honor.
Ms. Wood, any questions or concerns about that sentence?
No, Your Honor, thank you.
Okay, and to be clear, Mr. Ballard, you're going to get credit for all the time you've been in. It's not 3 more months, so you'll be getting out real soon. You go stay with your mom and stay out of trouble. Do you have any questions about anything we discussed?
No, sir, I'm fine.
All right, well, good luck with everything, and thank you, Ms. Willingham. We will see you maybe in the new year.
Yes.
All right.
All right, Judge.
Thank you, Ms. Wood.
You're welcome, Mr. Ballard. Take care.
All right.
All right, let's move to the Marietta Annex. I think you all are going to have to unmute. I don't think I can control that. Is it unmuted? Who do we have there? It's unmuted. Excellent. You are?
Lane Hammond.
All right, Mr. Hammond, I've seen you on the calendar. That's position 13. Who's handling that for Mr. Hammond?
Judge, so I did not go visit him because he's represented by private attorney Mike Moran on a new case that's the basis of this warrant. But I talked to Mr. Moran this morning, and he says that he's not been retained on the probation matter. So if Mr. Hammond would like for me to handle this, I'm more than happy. I've already talked to the state, so I think we have a stipulation that he would be interested in. So I'll just leave it in Mr. Hammond's court.
Okay, well, let me ask Mr. Hammond a few questions and also look at the notes I got from Ms. Tucson. All right, so Mr. Hammond, let's get on the record in your case. This is 19 SC 170171. Older case, you pled to theft by receiving stolen property and a couple other things. And you've got just about 7 months left on your probation in this case. You have no prior revocations in this case, so good history. But there is an allegation in a warrant that I signed in March of this year that you committed a new crime, aggravated assault, family violence battery, here in Fulton County in February of this year, and you were arrested in March of this year. What Ms. Wood just shared with me is that you've got a lawyer on that case, Mr. Moran, good lawyer, and you've retained him. You're paying him to represent you on that, but he does not represent you for any revocation hearing in this old case that you have. And so Ms. Wood, who is with the Public Defender's Office and can be appointed if you're wanting to do that, can represent you for this revocation, or we can take a time out and you and Mr. Moran can figure out what it might take financially for him to pick up this revocation, and we could reconvene at a later date to work through whatever that revocation may look like. Now, it sounds like Ms. Wood has already talked with the prosecutor and may have kind of worked something out, not knowing that you had the private lawyer on the other case. This is 100% your call. There is no pressure on you to go forward today because Ms. Wood is here, but you can, and Ms. Wood can certainly represent you, and she is a very able attorney and is in a position to do that. But that's your decision. I just need to know how you want to roll.
Oh, I will be totally fine with Ms. Woods handling the revocation.
Okay. Then Ms. Wood, why don't you tell me what's going on with Mr. Hammond, what maybe you've talked to with Ms. Clark about, and a little bit about the status of the new case. Is it indicted?
It is not, Judge. It's 23 CP 217088. I have been talking to Ms. Willingham and Mr. Peoples, so I think they might be handling this because this is a DV unindicted case.
Okay. Got it. And Mr. Peoples was here. He stepped out. He doesn't, Ms. Clark can handle the revocation, but he was here. Tell me, so it's unindicted. I'm looking it up right now, 217088. And by the way, just so you all know, starting January 1, CP cases will be called PI cases, for pre-indictment. So the first one, and we restart the numbers. So the very first PI in the new year will be 24 CP 0000, however many zeros, 1. So you'll know where in the year it hits, but it'll be PI going forward. All right, I'm just looking at the docket here. Has Mr. Hammond been in custody the whole time?
No, Judge. It looks like he got arrested based on the warrant on October the 30th.
Okay.
And this warrant is the only thing that's holding him in currently.
Got it. Okay. Well, tell me what you and a prosecutor have been discussing.
Thank you, Judge. So yes, so he has served 52 days. He has no prior revocations for this case, thanks to Ms. Toussaint's notes. I informed Ms. Willingham and Mr. Peoples I would be asking for time served. So those 52 days on the revocation, and we would be stipulating to the arrest only, since I don't know what's going, like anything about the new case, Judge. And I do want to point out for the court, I'm not sure, but I know that anyone that's housed at the Marietta Annex has to be doing very well in custody. So I do want to let the court know that.
Yes, no, I'm a big fan of the Marietta Annex. We rarely get folks who are there. Mr. Hammond, tell me how you ended up there rather than in the main jail.
I simply signed up for trustee. I own my own business on the street. I didn't want to get too comfortable with just laying down, sleeping every day. So I go to work as a trustee here at Fulton County Jail. Okay.
Let me add Ms. Wood so you can see her. There we go. And what is your main responsibility as a trustee?
I work in the kitchen. So
okay.
We work in the kitchen 8 hours a day.
Ooh, all right. And I'm sure you get paid, what, $22 an hour? Not so much. What is your business on the outside?
I own a company called Step Above the Rest Home Improvement. I also am a published author, and I also mentor kids. Okay.
Well, it sounds like you're involved in a bunch of important things. Unfortunately for you, you also got mixed up in something about which we're not going to discuss in March or February of this past year, and have these new charges. And that's what tripped you up on probation. If you get arrested for something, that's a violation of probation. So it sounds like through Ms. Wood, you're stipulating to the fact that you got arrested. That's not you admitting you did anything to anyone. You and Mr. Moran will work through whatever becomes of that situation. Let me take a quick look at that. Looks like the allegation is that you did something to Sharice Jackson with your challenger. But again, that's for you and Mr. Moran to sort out with a prosecutor. Ms. Clark, I don't know if you've been able to reach out to Mr. Peoples or Ms. Willingham. I didn't mean to put you in the awkward of, hey, I haven't really talked to anyone about this case. Do you have a recommendation from the state?
Ms. Wood is sending me the email, Your Honor, and according to the email that I'm reviewing, ADA Willingham is not opposed to Pete Wood's recommendation of a time served.
Okay. All right. Mr. Hammond, you have a place to go when you get out?
Yes, sir, I do.
All right. Is it your place or someone else's place?
No, mine. It's mine.
All right. Who lives there with you?
Me and my nephew.
Okay. You understand that when you are out, you're going to need to have no contact with whoever Ms. Jackson is to you. I'm confident that's a condition of your bond, but it's just going to make sense to not be tangling with her while these other charges are out there.
Yes, sir.
Okay. All right. Well, Mr. Hammond, I find you did violate the conditions of probation by getting arrested back in February. I'm going to revoke 60 days of your probation and reinstate the balance. That's going to leave you, like I said, with not a whole lot of money, about a half year left of probation. So hopefully you can navigate that with no further bumps in the road like you had been for a bunch of years. And that will be behind you. And all you'll need to sort out is this situation with Ms. Jackson. Do you have any questions about anything?
No, sorry, not.
All right. Ms. Tucson, do you have any reporting instructions for Mr. Hammond?
Mr. Hammond,
Yes, ma'am.
can you hear me okay?
Yes, ma'am, I can.
Do you have Officer Benton's number?
I do have a.
Okay, because that is who is showing as your officer. I know Judge just asked you where you were going to be living. I do need to take down that information.
Okay, it is gonna be 12101 Farrington Ridge Circle.
Okay, that's the one that I have. What is your number? 404-343-8966?
Yes, ma'am.
That's your current number?
Yes, ma'am.
Okay, just make sure when you do report, you know where Fulton County probation is?
I do not, because I've been on non-report for so long. I've never been to the office.
Right, because of the violation, even though you live in DeKalb County, it was sent back to Atlanta. So you have to report here, then they're gonna transfer you back over there
Okay.
to where you live. We're at 276 Memorial Drive. It's right around the corner from the Fulton County Jail. But you said you do have Officer Benton's number?
Yes, ma'am.
Okay, just give her a call, but just make sure you report here. I'm sure you could look it up, but it's 276 Memorial Drive, okay?
Okay, no problem.
In Atlanta. We're right around the corner, then they'll transfer your case over to be supervised, okay?
Okay.
So
Okay.
you to report, you'll get another warrant if you don't report.
Okay.
Okay.
Great. Thank you, Ms. Tucson. Thank you, Marietta Annex. You go back to cooking. I don't know what people are eating for lunch if you're sitting right there.
All right, thank you, Judge. Thank you.
All right.
You're
Bye-bye.
welcome. Good luck to you.
Thank you.
And thank you, Ms. Wood, for stepping in for that one.
You're welcome.
All right, let's go. I think this will be Mr. Sparrow. AC/DC, can you unmute, please? You did.
Yes,
It's
you're on
unmuted.
a minute. I'm going to it now.
You did it. It's unmuted. I can hear him. Are you Mr. Sparrow?
Yes, sir.
Great. We're going to handle your case. I think this is our only one from AC/DC, so they'll be done. And you are on for plea and arraignment. Who has Mr. Sparrow's case?
He's mine, Judge.
All right, let's get you on the screen too. All right. What are we doing, Ms. Wood, with Mr. Sparrow's case?
Judge, I filed a waiver this morning, so we are waiving formal arraignment, entering a plea of not guilty. And I'm happy to explain that to Mr. Sparrow. I've been meeting with him regularly, and Miss Ross is also involved. And so if he has any questions, I know the court will be able to explain as well.
Sure. So, Mr. Sparrow, what Ms. Wood did on your behalf was to file a piece of paper that says, right now, Mr. Sparrow says not guilty. I didn't do these things. That then requires the state, the prosecutor, to give to Ms. Wood all the evidence that the state has. You're charged with burglary and theft by taking. It looks like maybe a gun charge or something. The state has some reason to believe you were mixed up in that. So maybe there's surveillance video, maybe there's a witness who gave a statement. All that stuff is going to go to Ms. Wood. She'll meet with you, and you guys will be able to look over it and talk about it. And then Ms. Wood will figure out what's next in your case. Ms. Wood, I am noticing a booking number from 2022. Did Mr. Sparrow get out and then go back in, or has he been in since 2022?
Yes, I've been in since 2022.
Okay.
There are several other things that Mr. Sparrow is working through as well. At least one is unindicted, and then there are also some foreign county holds. I've been in touch with his pre-indictment attorneys, so we're trying to come up with something that will take care of everything at once.
Great. Well, maybe that's something Ms. Clark can help with before she moves on to other things. I don't know the facts of this case. The charges look like they are work-outable. I also don't know what the unindicted charges are. That sometimes can hang things up. But I trust you will work on that. If you've got Ms. Ross plugged in as well, that's a good sign. Mr. Sparrow, this case at least will start moving now. I'll get a scheduling order in place. That'll get that discovery to your lawyer. She'll meet with you. It sounds like your situation is a little more complicated because you've got an unindicted case and you're a popular guy. You're wanted in other counties as well. I can't control the other counties, but I can help move along the things that are charged here. Do you have any questions for me?
Yes, I'm just trying to get moved to my next county because I only got to go to one county, and that's my probation county, but my probation time is up. I talked to my probation officer. They said they want me to come down there and sign some papers so I can get off probation, because I got off probation last month. And they want me to come down there and sign some paperwork. So I'll be off probation. And I'm just trying to get home to get to my 6 kids, because my 6 kids staying with my sister. And my sister saying she's not going to be able to keep up with my 6 kids because she got her own 3 by herself.
Yeah, and 6 is a big number. So couple questions. What is this other county?
It's Dublin and Trutland County.
Okay.
I was riding.
Okay, you don't need to tell me what the event was, but it sounds like you're hearing that probation may be all done down in Trutland County.
Yeah, it's done, but they want me to come down there and sign some paperwork. But I was in the car. I was involved in the car down there. And,
that's good, Mr. Sparrow.
They said that
you don't need to tell me what happened down there. But we can work with probation up here. If things need to be signed, you don't necessarily have to go all the way back down there just to sign paperwork. So we'll look into that. The other question I had, you mentioned you have 6 kids. Where is their mom in the picture? You mentioned they're staying with your sister. Do they have a mom they could?
Yeah, their mom right now is going through it right now. She is in Kentucky right now. She's going through it right now. So she's trying to get on her feet. So I got my kids staying at my sister's house.
Okay. All right. Well, Ms. Wood, I know you've got your arms around this one and are ready to go with it. You'll see Mr. Sparrow soon, and we'll figure out how to move him along. Okay.
Thank you, Judge.
All right, Mr. Sparrow. It's nice meeting you. We'll keep this moving forward.
So I'm done today?
You're done today. You're free to walk away from the screen. I appreciate it. And I think that's all we had from ACDC on my list. So thank you, ACDC. Remove spotlight, and let's go here.
Good to see you again, Judge McBurney.
Same. Thanks for your help.
You're welcome.
All right. Where are you? I don't have McCoy listed on any email. I don't know what to unmute. Can you hear me?
Yes,
Hey, where are you guys?
we're at call.
Oh, this is another cop. It's just not booth one?
No, we have one in booth one. Two of the booths are down. We have IT coming to fix them. I have one guy in the booth one and one of the phone.
Okay, so who do we have on the screen now?
What's your last name? This Williams, booth one, and Carter right here.
All right, let's do Mr. Carter. It's a little tricky. The bandwidth is real bad right there. I don't know what device he's using. Can you hear me, Mr. Carter?
Yes, sir.
Okay.
Yes, sir.
Good. I can hear you. Who is handling Mr. Carter's case?
He's mine, Judge.
All right, let me get you on the screen. All right, there's Mr. Carter. There's Ms. Wood. Ms. Wood, what are we doing with Mr. Carter today?
Judge, we were hoping that we would be able to reach a negotiated resolution today for this case. We're not quite there yet. I'm happy to explain more in depth to Mr. Carter in a breakout. I've talked to him several times leading up to today's court date. So I think it's probably in his best interest for now to waive formal arraignment and enter a plea of not guilty.
All right. And if we're not able to resolve this now, just the two positions are too far apart?
I can do a breakout session, Judge, and see. I know I know pretty well what Mr. Carter was asking for. I'm happy to tell him what the state's response is and see if it changes anything for him. I'm happy to do that.
Okay. And Ms. Clark, this is your case?
Yes, sir.
Okay. All right. Let me see if we can pull that off, and you two can talk. Hold on. No.
In the alternative, Judge, if I need to do like a phone call, I know I've done that with Cobb before. I'm happy to do that as well.
Let's see what happens.
Okay.
Hold on. So, Mr. Carter, I'm going to put you and Ms. Wood in a breakout room. And so what you say is private. I don't know who's in the room with you, Mr. Carter, but beyond that, no one can hear what you two are saying. It'll be a confidential conversation. I won't hear it. The prosecutor won't hear it. It's as if you two were in a room. Okay. So I'm going to see if this works. If it doesn't, you'll pop back out. You were in a good spot. I don't know. And Ms. Wood. I hope this works. I don't know why they moved. All right, let's find our next person. Oh, there was someone at the jail.
Keep going, man.
Good morning. Who's in 4 South Booth 1?
Brown. D'Anthony Brown.
All right, Mr. Brown, I'm Judge McBurney. I'm looking for you. Here you are, position 14. All right. Ms. Clark, do you know who's handling this for Mr. Brown?
It'll be Ms. Wood.
Ms. Wood, okay. Ms. Wood.
Your Honor, I think, disregard, I was thinking that Mr. Matthews was the attorney.
I think that was his attorney originally.
No, Mr. Matthews is not on the case. He sent an email yesterday.
Yeah. Okay. No, it's Ms. Wood, and that's great. That's who we happened to push into a breakout room. Let me see if I can get her.
I do have some notes on Mr. Brown.
All right, Ms. Wood should be back. I just tried to close all the rooms.
I'm back, Judge.
Hey, welcome back. The McCoy phone popped out right away, so I don't know what happened there. We're going to return to that discussion in a minute. We've got Mr. Brown, position 14 on the screen, and he says to me that you are his lawyer for this revocation.
I did speak with him, Judge. I am ready to go forward on this.
Great. Well, let's get on the record then for Mr. Brown. Position 14, it's 22 SC 182797. And let me look at the notes here. Okay, so Mr. Brown is on probation for possession of a firearm by a convicted felon. He has 2 years and a little under 5 months remaining. No prior revocations. The allegation on the warrant that I signed in August of this year is basically that Mr. Brown had absconded. They couldn't find him, went to girlfriend's house, says she doesn't know how to find him, then contacted Mr. Brown through an app. He says he's having to bounce from place to place. Was told nonetheless to report, and he didn't do so. So failure to report. Ms. Wood, is Mr. Brown admitting to this violation?
We'll admit, Judge.
Okay. What are you recommending for a revocation and, more importantly, a going forward approach so that Mr. Brown stays connected with probation?
Judge, we are asking the court to consider revoking 60 days and reinstating. He has been in since October the 26th, so he served 56 days. I would just like to let the court know he is in no bond status on the unindicted case, and he also has a Clayton County hold. So he will need to work through both of those matters before he's actually released. And he does have a stable address now, so I think it'll be easier. He's going to be living with his aunt and his mother when he gets out. So I think that'll help resolve some of the issues, Judge.
Okay. Tell me the unindicted case.
The case number is 23 CP 222919.
Okay. All right. And it looks like Mr. Brown has a preliminary hearing tomorrow. So you'll be going to court tomorrow, Mr. Brown, and a lawyer on your behalf will be arguing that there's not probable cause to support these new charges that you've got. We'll see what Judge Drake does with that, but we're here on a different situation. So your request, Ms. Wood, is revoke 60 days, reinstate the balance, and Mr. Brown is stuck in two ways. He's got no bond, and if the court finds probable cause, that probably won't change because that Judge Drake only recently denied a bond modification and there's a foreign hold. Got it. Okay. Ms. Clark, what is your recommendation here?
Your Honor, the state is fine with, following, PD Wood's recommendation of the revoking 60 days and with the fact that he does have, he's in no bond status on the other case and he has a hold.
Okay.
We're not opposed to reinstate.
All right. What's the stable address that you've got, Ms. Wood? Because I want to make sure that goes into the system for Ms. Tucson.
942 Hank Aaron Drive, apartment A10, here in Atlanta with a 30315 zip code.
All right. Mr. Brown, who lives there besides you?
My aunt, my mom.
Your aunt and your mom?
Yes, sir.
All right. And they'd be okay with you staying there if you got out?
Absolutely.
Okay. All right. And what county did you say Mr. Brown had a hold in?
It's Clayton, Judge.
Clayton. For what?
I believe it's a fleeing and eluding.
Okay. It's an unresolved charge.
I believe so.
Okay. All right. Anything else, Mr. Brown, you're aware of, or it's you got these open charges with no bond in Fulton and then that situation in Clayton? That's it?
Yeah, that's it.
Okay. All right. Well, that's plenty. I don't need you to have more, but that's plenty. Ms. Tucson, did you get that address?
I did not. I heard the part about he was going to be staying with mom.
Okay, 942 Hank Aaron Drive, apartment A10.
Okay, because we have something different on file for that. 942 Hank Aaron
Drive, apartment A10, 30315.
A like apple.
A like apple.
And Mr. Brown, do you have a phone number or your mom has a phone number?
My mom is 404.
40, it's kind of hard to hear. Let me turn my volume up. 404
729
729
2456.
2456. Okay. And just make sure whenever I know you're going to be transferring around places, but just make sure you do report to probation when you are able to, okay?
Okay.
All right.
So I want to be clear, the only basis for revocation before me right now is the failure to report. And hold on one second. On that basis, I will revoke 60 days and reinstate the balance. That doesn't mean in the future we might not be back together because of the new charges in either Clayton or Fulton. The 60 days I view as the revocation in connection with the allegation in the petition, which is the failure to report. Ms. Wood, anything else on behalf of Mr. Brown?
No, Your Honor, thank you.
Okay, Ms. Clark?
No, Your Honor.
All right, so Mr. Brown, that'll close out the revocation. It's not really gonna move you anywhere. Like I said, you'll come to court tomorrow for your preliminary hearing, and you'll see how that goes, and then we'll see what's next, okay? Any questions?
No, sir.
All right, thank you. Ms. Wood, I don't know if you were able to speak to Mr. Carter or not?
I was not, Judge, but it looks like he may have moved into a different booth.
Okay, well, let me just mark that this is taken care of. See who we can find. Hey, who's in Cobb booth 1?
Mr. Carter, Ricky Carter.
Oh, Mr. Carter, again, I can see you much better. It's a better camera and everything. All right. Ms. Wood, you want to try a breakout with Mr. Carter now that he's in a quieter spot?
Yes, Judge, please.
All right. So you don't have to do anything, Mr. Carter. But if this works, you and Ms. Wood will be able to have a private conversation. Let's see if I can make it work.
Yes, sir.
Wood. It's not going to work, Ms. Wood. Cobb booth 1 isn't showing up as something that I can move, which is weird.
Judge, so Ms. Clark and I are still negotiating. I'm not sure how many other positions we have, but if we can come to an agreement, we can probably move forward with Mr. Carter without the breakout session. It just depends.
Okay. Let me see. The other option would be we could get Mr. Carter on a phone there. It looked like that deputy who was helping out actually was using a phone. But regrettably, I can't, it's not recognizing the Cobb booth as a movable thing, something that I can drop in there. So let's see. Why don't you guys keep talking? We do have a few more positions. There's Mr. Williams. I think that's Ms. Feely's case where it's arraignment and bond reduction. And then Mr. Tolles has a case too. I don't know where that defendant is, but we'll figure that out. So let me look. Let me close this.
Evans, I believe, is in Cobb County, Judge.
Also in Cobb. So if I go back to that email that you got, Evans and Williams. So I think our last two are there in Cobb. So Mr. Carter, I'm gonna have you step out of the booth and someone's gonna come in, but don't leave. We may be able to sort things out and we'll see who's coming in. Hey, good morning. Who are you?
Mr. Williams.
All right, I'm Judge McBurney. Nice to meet you, Mr. Williams.
You too.
Ms. Feely, are you ready?
Yes, Your Honor.
All right, let me get you on the screen. And all right. So Ms. Feely, we've got an arraignment and a bond reduction motion. If this isn't a case that's resolving, it's a burglary charge. Tell me how you'd like to move forward.
So this was one that I was thinking maybe low hanging fruit that we could resolve. It's just a matter of I wasn't able to get up to Cobb last week to see Mr. Williams, but if it's worth us talking, I may be moot if we can't have breakout sessions, but I could call Mr. Williams if we could try to get this taken care of that way.
Okay, well, let's see, because that's more effective than a bond reduction. Mr. Williams, do you know, there's a deputy out there who seemed like she had a phone. Is there a way we can get people on a phone or not?
Yeah.
Okay. If you could get the deputy to poke her head in, that would be great.
Okay.
Thank you.
Hey, Ms. Andrews. Okay. Yeah.
Yes.
Hey, how are you?
Fine, sir.
So there are two different gentlemen, Mr. Williams, who's sitting right there with you, and then Mr. Carter out there, who need to have a conversation with their lawyer, but I can't get the booth into a breakout room. And so I was wondering, is there a phone number that the lawyer could call so that Mr. Williams or Mr. Carter could have a quick conversation with the lawyer?
Yes, sir. Let me find my number to the county phone. Hold 1 second.
Great.
470-927-0845.
So why don't we start, Ms. Feely, since you're right there, why don't you call that number, and Mr. Williams, you're gonna talk with Ms. Feely. We'll see if we can work your case out. If not, we'll still go forward with the arraignment and whatnot. And then we'll get Ms. Wood on the phone with Mr. Carter, okay? So you're welcome to step out of the Zoom world for a little bit, and we'll see what else we can do.
Thank you.
Thank you. All right, so let me see if I can find. Oh, why I don't have an Evans. Is that a separate calendar? Here, no.
Yes, Judge, it's an add-on jail Zoom calendar.
All right, I don't know that that was on, that I found that one. Let's see.
I'll send it to you.
That's okay. Let me just see if it's here. Supplemental calendar. Whoops. Why'd that move? No, that's Anthony Kennedy.
It's an add-on jail Zoom calendar.
I know, but it's just, it's not listed on the attachments for today. So if you don't mind forwarding that to me, please.
Judge McBurney, that's my case.
Yes, Mr. Tolles, how you doing?
Yes, I'm still awaiting a offer from the state. If you, while y'all sorting that out, I can go in here and finish my business in Clayton, but I'm still waiting on a recommendation.
Well, don't go anywhere. I need to see this calendar. I need to know what, so it looks like, the warrant that I signed in September alleges that in February, Mr. Evans picked up, some new charges, fleeing and attempting to elude, a couple things like that. Ms. Clark, would this be your situation?
Yes, Your Honor.
Okay, so Mr. Tolles, what's the best way for Ms. Clark to communicate with you?
She can call me on my cell phone or just do the chat.
Okay. Do you have Mr. Tolles' cell phone number?
No, Your Honor, I don't.
Maybe he'll send it to you through the chat, so it's not live on YouTube. So Mr. Tolles, if you would send through the chat to Ms. Clark your cell phone, she can call you. You guys can discuss. Mr. Evans is probably ready to go there in Cobb, and we'll see what we can do.
Okay, thank you.
Sure. All right, so I think we are on hold for now. We got to sort out Evans and, oh, and there's Kennedy. Need to work through as well.
Your Honor, that case, 19 SC.
Mr. Evans's case?
Yes, Your Honor.
I've got the calendar now.
Oh, okay.
I'm good.
No, I'm asking for myself, 19 SC 170465. Okay, all right.
That is it.
Okay. Thank you.
You bet.
Mr. Toles told me, to give him a moment to, before I call.
Okay.
I just want you to know.
No, thank you.
Okay.
Ms. Feely or Ms. Wood, are either one of you done with your phone communication with your client at Cobb?
I am done with my phone communication, and I think that we're going to be ready to proceed with a plea in Mr. Williams' case.
Great. Can we do that now, or do you need more time, or are you and Ms. Clark? It's all kind of, you're texting and emailing, so I don't hear it, which is fine with me. I just don't want to rush anyone, but I'm sitting here ready to roll. So should we get Mr. Williams in there and do the plea?
I believe so.
Okay. That's not yes 100%.
I think the things that need to be cleared up, I could call him, or I could, I believe Miss Wood's on the phone right now, though, is the only reason I haven't done so.
Okay, it's not something that you could talk about in front of us.
I think we probably could. That's why I think we are close enough to ready that it may not be the smoothest plea that's ever been taken, but we could probably get through it.
Okay, well, let me unmute and see who we got right there. Hey, booth one, who do we got right there?
Evans.
Evans, I need Williams.
Okay, he's coming.
Thank you. We caught you changing?
I had to get a sweater.
They gave him a sweatshirt to put on.
Oh, good, a little chilly in there. All right, well, let's get booth one on there, and Ms. Feely on there, and Ms. Clark. Okay, great. So Mr. Williams, Ms. Feely says that she thinks you all have worked something out and that you want to go forward with a plea. There may be one little hiccup. It doesn't sound like it's major, but we will see what that is. Ms. Feely, is there anything you want to cover before we get on the record?
Sure. Mr. Williams, so when we were talking, it was kind of we were going to see if the prosecutor went with what we talked about, and they have. But do you have any other questions that I may need to call you for beforehand?
No, ma'am.
Okay, and the other thing was, my understanding is that when you are released, you're going to go return to Kentucky. Is that right?
Yes, ma'am.
Okay, Ms. Clark, is that that's where he's from? So,
All right, that's official. Thank you.
I think we're ready then.
Great. So, Mr. Williams, we're going to get on the record. Your case is 23 SC 190437, State versus Martin Williams. Mr. Williams is represented by Ms. Feely. Ms. Clark represents the state. Mr. Williams, two things I need to get clear on with you before we can go any further. You have a right to be here in court, but you can waive that right and say, you know what, I'm okay being in booth one at Cobb County Jail. I'd like to take my plea right now. Are you okay proceeding from there?
Yes, sir.
You also have a right to have Ms. Feely right next to you, so you don't have to borrow a deputy's phone to talk to her in private. But she is at her office and you are in booth one at Cobb County Jail. Are you okay with us proceeding with Ms. Feely in a different place than where you are?
Yeah, that's fine.
Okay. If at any point you need to speak with her in private, will you let me know?
Yeah.
Good. We'll figure out how to do that. All right. Then in just a moment, Ms. Clark, the prosecutor, is going to put you under oath. Once you're under oath, make sure you answer all of her questions and mine truthfully and completely. Also, make sure that you let me know if you've got any questions because you can't hear us, because the connection is bad, or whatever is being discussed just doesn't make sense. Will you do that?
Yes, sir.
All right, let's roll.
Please raise your, Your Honor, for the record, the state will be, for count one, the state will be, making the recommendation to amend that charge from burglary in the first degree to criminal trespass under 16-7-21.
All right, so misdemeanor plea.
Yes, sir.
Got it.
Please raise your right hand. Do you swear or affirm that any evidence or testimony that you shall give in the matter currently pending before this court shall be the truth, the whole truth, and nothing but the truth under penalty of perjury?
I do.
Please state and spell your correct legal name.
MARTIN space ALAN space WILLIAMS.
You can put your hand down.
Are you at this time taking or under the influence of any medicine, drugs, or alcohol?
No, ma'am.
Is there a medication that you normally take that you've not taken or been given today?
No, ma'am.
How old are you?
I'm 32.
What's the highest level of education or the last grade you completed?
A year and a half in college.
Are you able to read, write, and understand the English language?
Yes, ma'am.
Do you understand that you've been charged with the following offenses? Count 1, burglary in the first degree, but the state will be recommending a reduction to criminal trespass under 16-7-21, and count 2, theft by taking, misdemeanor.
Yes, ma'am.
Do you understand that you have the right to plead either guilty or not guilty to these charges?
Yes, ma'am.
Do you understand that if you plead not guilty or remain silent, then the state is required to prove the charges against you at a jury trial?
Yes, ma'am.
Have you had an opportunity to review the indictment with your attorney?
No.
That's a charging document. So I was not able to see him last week. So that may be, if you have questions about that, we may need to.
I don't got no questions though, but
Okay. No, you gave an honest answer, which is exactly what you're supposed to do. In the indictment, I've got it in front of me right here. It charges you in count 1 with burglary, but that's being reduced to criminal trespass. And Ms. Clark's going to go over the facts. Something happened in October of last year. And then count 2 charges you with misdemeanor theft by taking. And the allegation is that you took some things that belonged to Julio Jones, clothes and jewelry. So that's it. It's the burglary, which is now criminal trespass, and the theft by taking. That's what the indictment says, and that's what you're pleading to, except that that first count's being reduced to the misdemeanor of criminal trespass. Do you have any questions about that?
Yes, sir.
Okay, let's keep going.
Have you had enough time to speak with your attorney about the charges in the indictment against you, including the facts and circumstances relating to this case?
Yes, ma'am.
Are you satisfied with your attorney's services?
Yes, ma'am.
Attorney Feely, do you waive a formal reading of the indictment?
We do.
Do you waive any defects in the indictment for purposes of this plea?
We do.
Defendant Williams, has your attorney advised you of the minimum and maximum sentence for each charge to which you're pleading guilty today?
Yes, ma'am.
The state will provide those for count 1, criminal trespass. The minimum is 1 day in jail. The max is 12 months in jail. For count 2, theft by taking, misdemeanor, the minimum is 1 day. The max is 12 months in jail. Do you understand that you are entering a negotiated plea of guilty, which means that the state and defense jointly will recommend the following sentence to the court? For count 1, criminal trespass, the state's recommendation is 12 months to serve.
Yes, ma'am.
For 12 months to serve, and the defendant will get credit for the time that has already been served. For count 2, the state's recommendation is theft. The state's recommendation is 12 months probation, to be consecutive to count 2, but commuted to time served. Is that your understanding of the negotiated plea?
Yes, ma'am.
Do you understand that the court is not required to accept the state's recommended sentence?
Yes, ma'am.
Do you understand that the court has the right to sentence you to the maximum possible sentence on each charge?
Yes, ma'am.
Do you understand that if the court decides to order a sentence that differs from the negotiated plea you were expecting today, that you have the right to withdraw your plea of guilty?
Yes, ma'am.
Are you currently on probation or parole?
No, ma'am.
Do you understand, excuse me, disregard that. Are you a United States citizen?
Yes, ma'am.
Do you understand that if you're, oh, excuse me. I wanted to, PD Feely, will your client, the state has information that indicates that the defendant may qualify for first offender. Do you know if your client will be seeking first offender status?
I didn't speak with him about that specifically, but I would not be recommending that to him. So I'm happy to call and discuss that. If Mr. Williams, if you want to discuss that further.
No.
Talk to him about it. And then if he wants to speak with you in private, I'll afford him that opportunity.
So we talked about it, a topic that was kind of adjacent to that made me believe that he would not want to use first offender on this case. But Mr. Williams, if you have any other questions about that, let me know.
No, I don't.
Okay.
That's correct.
Do you understand that by entering a plea of guilty today, you are waiving all defenses, including any mental health defenses?
Yes, ma'am.
Do you understand that by pleading guilty, you're giving up the following rights? The right to a trial by jury, the right to remain silent, the right to confront witnesses against you, the right to subpoena witnesses on your behalf, the right to testify or offer other evidence, the right to the assistance of counsel, the right to the presumption of innocence, the right not to incriminate yourself, and the right to appeal if convicted of these charges at a trial. Is it your decision to waive these rights, which means not to use them, and to enter a guilty plea today?
Yes, ma'am.
Has anyone forced, threatened, coerced, or promised you anything to get you to enter this guilty plea?
No, ma'am.
Is it your decision to enter a guilty plea because you are in fact guilty?
Yes, ma'am.
As to indictment 23, excuse me. Sorry, Defendant Williams, one moment, sorry. As to indictment 23 SC 190437, how do you plead to count 1, criminal trespass?
Guilty.
How do you plead to count 2, theft by taking misdemeanor?
Guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes, ma'am.
Do you understand that you only have a limited right to appeal this guilty plea conviction?
Yes, ma'am.
Do you understand that if you wish to file a direct appeal, you must do so within 30 days from today's date?
Yes, ma'am.
Do you understand that if you wish to challenge the voluntariness of your guilty plea, you must do so by filing a habeas corpus petition?
Yes, ma'am.
Do you understand that for a misdemeanor charge, you only have 12 months from today's date to file that petition?
Yes, ma'am.
At this time, the state will provide a factual basis for the misdemeanor plea in this case. Your Honor, if this matter would have went to trial, the state would have been able to prove beyond a reasonable doubt that on October 11th, 2022, officers from Atlanta Police Department were dispatched to a criminal trespass located at the incident location of 2883 West Roxborough Road, Northeast, Atlanta, Georgia, in Fulton County, in regards to a burglary report. Officers met with property manager Amy Milam, spelled M-I-L-A-M, who stated that a young black male, later identified as the defendant, Martin A. Williams, was squatting in the home for about a week. The residence belongs to the victim, Julio Jones. Amy Milam indicated that she and a few other family members found the defendant living in the home. Amy Milam indicated that there were multiple TV boxes that were open in the home that also contained watches. There were TV boxes that were open in the home that previously contained watches and shoes, and those items were missing. APDI officers did a perimeter check and were able to find the route that the defendant Williams had actually been through in the house. Defendant Williams was able to walk from the street to the corner of the property, squeezing through the wood line to evade officers. This was not the first time the family had encountered defendant Williams. On October 7, 2022, the brother of Julio Jones, Philip Jones, stated that he recorded and took pictures of Martin A. Williams in the home. Philip Jones recorded it and captured him telling Martin A. Williams multiple times to get out of the home and to take his brother's clothes headphones, jewelry, and shoes off. Nothing further from the state, Your Honor.
All right. Is this Julio Jones the same Julio Jones who's a pro football player, or it's just a guy with the same name?
Your Honor, to my understanding, it's the guy with the same name.
Okay, it's not an NFL player.
I think it might be.
One moment. It actually is. I stand corrected. It is the same Julio Jones.
Okay, just curious. Doesn't change things. Let me get a little more information, Mr. Williams, about you, and then I'll hear from Ms. Feely. Ms. Jackson, do you have any criminal history information on Mr. Williams, position 7?
He has 14 cycles. The last arrest was September the 1st, 2022 in Doraville, Georgia, where a failure to appear, a misdemeanor theft by shoplifting was the underlying charge. There was no disposition. He does appear to have an outstanding hold out of Doraville, Georgia for a failure to appear. The date on that warrant was November the 27th, 2023. I do see 2 failure to appears. It's one in 2022 and one in 2016. I'm sorry, 2016. Nothing in addition, Your Honor.
All right, thank you so much. Ms. Feely.
Thank you, Your Honor. Just so I don't forget, I believe the November or September 2022 failure to appear, if it was an arrest in September 2022, he probably was in Fulton County custody at the time that his court date would have come up for that. But in any event, I don't think that affects anything else here. As you heard, Mr. Williams is 32 years old. He is single. He has no children. He has done pretty much everything you can do in a factory. He's forklift, any kind of factory work he has a lot of experience with, as well as construction. As he mentioned, he studied pre-physical therapy for 1.5 years at Western Kentucky College. He is from Kentucky. He graduated high school in Kentucky, and he hopes to return. He has extended family here in the Atlanta area. So he temporarily relocated in March of 2022, but it doesn't seem to be a good fit for him. So he is hoping to return where his nuclear family is in Kentucky. He doesn't have any felonies. And he's not, this was a property kind of crime. He wasn't doing drugs. He wasn't having guns. He wasn't hurting anyone. But I think, as the court said, it shouldn't matter whether this is that Julio Jones or not, but I think it did matter because he didn't have a bond for quite a number of months. He does have a bond now, but it's not one that he's going to be able to post anytime soon. So we are asking the court to accept the negotiated recommendation.
Has Mr. Williams really been in custody for 435 days?
He has.
Whew, okay. Mr. Williams, how did you figure out that this was a place to hang out in? Did you know Mr. Jones beforehand, or you just knew that this is a place where there'd be nice clothes and nice jewelry?
Oh, no. I actually got invited to an Airbnb, so that's how I knew about it.
Okay. All right. Anything you want to add?
No.
Ms. Clark, it doesn't sound like there's any restitution owed, that even though there's a theft charge, Mr. Jones isn't seeking any restitution?
No, Your Honor.
Okay, got it. Well, Mr. Williams, I find there's a factual basis for your plea to criminal trespass, as well as your plea to theft by taking, that your plea is knowing and voluntary. Voluntary means no one's forcing you to do this. Knowing means you've understood all the things we've talked about. Do you agree with that?
Yes, sir.
I got to talk to you real quickly about first offender. It sounds like you're not interested in doing that, and that makes sense. First offender is something you're eligible for. It would mean that this would not show up as a conviction on your record, but you need to know that you get to use first offender one time, whether it's for a misdemeanor or a felony, and the state has agreed to reduce the felony charge you had to a misdemeanor. So if you were to take first offender status, and I'm not forecasting the future, but if you got in trouble in the future and it was for a felony, you couldn't use first offender. You would have used it up on a misdemeanor, for which you're just going to get time served. So your criminal history will show that you have a misdemeanor conviction, but you'd still have that first offender option in your pocket. Do you want to use first offender on this misdemeanor case, or hold on to it?
I'm gonna hold on to it.
Okay. We'll do it that way. And it sounds like you're ready to go back to Kentucky.
Yeah.
Okay. Well, Mr. Williams, I'm going to sentence you to 12 months to serve on count 1 and 12 months to serve on count 2. Those will run concurrently with each other, meaning at the same time. You'll get credit for the time you've served, and you can do the math as well as I can. You've done more than 12 months, so you ought to be released today or tomorrow. It takes a little while to process the paperwork. If you are still in tomorrow and it's lunchtime, you should reach out to Ms. Feely and she'll let me know, and I'll reach across to the sheriff to make sure your paperwork is moving through the system. Ms. Clark, oh, one last thing. Mr. Williams, well, I'll start with Ms. Feely. Ms. Feely, can my office electronically sign your name to the indictment for the 2 misdemeanor pleas of your client?
Yes, Your Honor.
Mr. Williams, is it okay if we electronically sign your name to it?
Yeah, that's fine.
And Ms. Clark?
Yes, Your Honor.
We will do that. Ms. Clark, anything else on behalf of the state here?
No, Your Honor.
Ms. Feely?
No,
On behalf of Mr. Williams?
no, Your Honor.
No.
No? All right, Mr. Williams, you look like you're about to jump out of the little booth there. Do you have any questions?
No.
You're good? All right, go use the restroom, whatever you need to do.
All right.
And can you send, all right, Ms. Wood, what are we doing with Mr. Carter?
It's a plea, Judge.
Okay. Mr. Carter, how you doing?
Real good, sir. So far, so good.
So far, so good. Well, let's try to keep it that way. Let me add Ms. Wood and do one thing first. All right. Mr. Carter, Ms. Wood tells me you're prepared to enter a plea in your case. Is that correct?
Yes, sir.
Okay. Ms. Rivers, are you good? I know you were able to sneak in a break a little bit earlier. Are you good with one more plea here?
Yes, Judge, I'm on the record.
Great. Mr. Carter, we're going to go on the record with your case. It's 23 SC 190-693. You're charged with fleeing or attempting to elude. Before Ms. Clark can start the plea process, I need you to tell me you're okay with 2 things. Number one, you're not here in court, which you have a right to be in open court, public court. People can watch what's going on. You're in booth 1 at the Cobb County Jail. Are you waiving your right to be present here in court?
Yes, sir.
Okay. The other right you need to tell me about is your right to have Ms. Wood sitting right next to you so that you could lean over and talk to her or ask her a question. As you have learned, she is somewhere else. And so if you want to speak to her privately, you need to do it over the phone. Sounds like you all have been able to speak several times this morning, and you should be good to go. Are you okay proceeding with your plea with Ms. Wood in a place other than where you are?
Yes, sir.
Okay, if you have any questions for her, let me know. In fact, if you have any questions at any time, will you let me know?
Yes, sir.
All right, Ms. Clark, when you're ready.
Thank you, Your Honor. Your Honor, for the record, the state will be making the sentence recommendation to amend both counts 1 and 2, the felony fleeing or attempting to elude. Both of those, the state will be recommending reductions to misdemeanor reckless driving under 40-6-390.
Okay, and so the record's clear. You don't get a recommend, you get to do. So it's not my call whether you reduce. It was the same with Mr. Williams's case. It sounds like you are electing, as the assistant DA handling the case, to reduce felony fleeing or attempting to elude to misdemeanor reckless driving.
Yes, Your Honor.
Okay, got it.
Okay. Please raise your right hand. Do you swear or affirm that any evidence or testimony that you shall give in the matter currently pending before this court shall be the truth, the whole truth, and nothing but the truth under penalty of perjury?
Yes, ma'am, I do.
Please state and spell your correct legal name.
Ricky Ahmad Carter, RICKY-AHMADCARTER.
Are you at this time taking or under the influence of any medicine, drugs, or alcohol?
No, ma'am.
Is there a medication that you normally take that you have not taken or been given today?
No, ma'am.
How old are you? Oh, I'm so sorry, Defendant Carter. Please, you can put your hand down. My apologies. Is there a medication that you normally take that you have not taken or been given today?
No, ma'am.
How old are you?
22.
What's the highest level of education or the last grade you completed?
I got my equipment, my GED.
Are you able to read, write, and understand the English language?
Yes, ma'am.
Do you understand that you've been charged with the following offenses? Count 1, reckless driving under 40-6390, as the state will be amending the charge from the felony attempting to elude that was originally indicted in this case. And for count 2, the state will be amending that charge to reckless driving under 40-6-390 for the same for the second separate charge of fleeing and attempting to elude.
Yes, ma'am.
Do you understand that you have the right to plead either guilty or not guilty to these charges?
Yes, ma'am.
Do you understand that if you plead not guilty or remain silent, then the state is required to prove the charges against you at a jury trial?
Yes, ma'am.
Have you had an opportunity to review the indictment with your attorney?
Yes, ma'am.
And did you understand the indictment as explained to you by your attorney?
Yes, ma'am.
Have you had enough time to speak with your attorney about the charges in the indictment against you, including the facts and circumstances relating to these charges?
Yes, ma'am.
Are you satisfied with your attorney's services?
Yes, ma'am.
Attorney Wood, do you waive a formal reading of the indictment?
So waived.
Do you waive any defects in the indictment for purposes of this plea?
We do.
Has your attorney advised you of the minimum and maximum sentence for each charge to which you're pleading guilty today?
Yes, ma'am.
The state will provide those. For the offense of reckless driving, the minimum is 1 day in jail. The max is 12 months in jail.
Yes, ma'am.
One moment, Your Honor. Do you understand that you are entering a negotiated plea of guilty, which means that the state and defense jointly will recommend the following sentence to the court? For count 1, reckless driving, the state's recommendation is 12 months probation. And the completion of a driver safety course within 60 days of the disposition of the case. And the defendant must complete 50 hours of community service. For count 2, the state's recommendation is 12 months probation to run consecutive to count 1. And the state's recommendation is to also complete the driving class to satisfy this same provision and the 50 hours of community service for this one, for this count 2, but it would only be it would only be 50 hours of community service. Is that your understanding of the plea? And if it was confusing, let me know, because I was confusing. Did you understand that?
I heard everything he said, but so is that like 2 years on probation?
Yeah, it's 2 years, so 24 months of probation, 50 hours community service, and then that driver safety course.
Yes, ma'am. I understand.
Okay. Do you understand that the court is not required to accept the state's recommended sentence?
Yes, ma'am.
Do you understand that the court has the right to sentence you to the maximum possible sentence on each charge?
Yes, ma'am.
You understand that as there are multiple charges to which you're pleading guilty today, the court also has the right to run those counts consecutively, meaning one after the other.
Yes, ma'am.
You understand that if the court decides to order a sentence that differs from the negotiated plea that you were expecting today, that you do have the right to withdraw your plea of guilty.
Yes, ma'am.
Are you currently on probation or parole?
No, ma'am.
Do you understand that if you're on probation, you must follow all the special conditions of your probation?
Yes, ma'am.
Do you understand that if you fail to follow all the special conditions of your probation, then you will be subject to revocation of that probation for the balance of your sentence.
Yes, ma'am.
Special conditions for this probation are to complete a driver safety course within 60 days of the closeout of this case, and also 50 hours of community service. Do you understand that you are not allowed to possess or use a firearm while on probation?
Yes, ma'am.
Are you a United States citizen?
Yes, ma'am.
Do you understand that by entering a plea of guilty today, you're waiving all defenses, including any mental health defenses?
Yes, ma'am.
Do you understand that by pleading guilty, you are giving up the following rights? The right to a trial by jury, the right to remain silent, the right to confront witnesses against you, the right to subpoena witnesses on your behalf, the right to testify or offer other evidence, the right to the assistance of counsel, the right to the presumption of innocence, the right not to incriminate yourself, and the right to appeal if convicted of these charges at a trial. Is it your decision to waive these rights, which means not to use them, and to enter a guilty plea today?
Yes, ma'am.
Has anyone forced, threatened, coerced, or promised you anything to get you to enter this guilty plea?
No, ma'am.
Is it your decision to enter a guilty plea because you are in fact guilty?
Yes, ma'am.
As to an indictment number 23 SC 190693, how do you plead to count 1, reckless driving?
Guilty.
How do you plead to count 2, reckless driving?
Guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes, ma'am.
Do you understand that you only have a limited right to appeal this guilty plea conviction?
Yes, ma'am.
Do you understand that if you wish to file a direct appeal, you must do so within 30 days from today's date?
Yes, ma'am.
Do you understand that if you wish to challenge the voluntariness of your guilty plea, you must do so by filing what is called a habeas corpus petition?
Yes, ma'am.
Do you understand that for a misdemeanor charge, you only have 12 months from today's date to file that petition?
Yes, ma'am.
At this time, Your Honor, the state will provide a factual basis for the misdemeanor plea in this case. One moment, Your Honor. If this matter would have went to trial, the state would have been able to prove beyond a reasonable doubt that on Wednesday, July 6th of 2022, at 2:30 a.m. in the morning, officers were patrolling the location of West Camilton Street at the intersection of Camilton and Fairburn Road in Fairburn, Georgia, in Fulton County. The officers were in marked patrol vehicles when they observed a white Toyota Corolla bearing a blue dealer tag WPJ350 turn onto West Campbellton Street at a high rate of speed and cross over the solid yellow line into the opposing traffic lane. Officers activated their lights in the marked patrol car and advised radio that they were attempting to catch up with the vehicle. The defendant that was later apprehended in the chase with the police was the defendant in this case. Officers were able to observe that the defendant was driving at a high rate of speed as he continued down Red Fox Court, as well as he turned left onto Tall Deer Drive at a high rate of speed, and also began to driving at a speed of 72 miles per hour when the car he was driving moved into a residential area. The traffic conditions at the time, the streets were dry, and there was minimal light at this time. Nothing further from the state.
So it sounds like no one was injured. It was clearly eluding, but also reckless. And so you're exercising your discretion to say, we're going to treat this as a reckless driving situation.
Yes, Your Honor.
Okay. All right. Ms. Jackson, do you have criminal history information for Ricky Carter?
Yes, Your Honor. He has 2 cycles. The last arrest was July the 10th, 2023 in Fulton County for battery family violence. That charge was dismissed September the 12th, 2023. There are no convictions listed in the GCIC. Nothing in addition.
Thank you, ma'am. So, Ms. Wood, I am struggling to understand the amount of time Mr. Carter has been in jail on this. There were 2 entries in Odyssey. One was for 255 days, and then maybe he got out. And then there's another 164 days that may be tied to that case Ms. Jackson just mentioned. Judge Drake, it got upgraded to aggravated assault. Judge Drake dismissed it because the officer from Fairburn failed to show up to the prelim. And so she dismissed the charges. Was he in for 255, of which the 164 was a portion, or did he lose his bond, or what's the math that you've got for Mr. Carter?
Judge, I believe it is 2 separate. So the total is 419 days. The first one, it's my understanding he was in for the 255 days and then got out. And he may be able to help clarify. I think it was Judge Manning that actually revoked the bond at some point, and then that case was dismissed, and so he's just been in this limbo since then. So he's been in this time 164 days, Judge.
Okay.
So it's a lot of time accrued.
Yeah, for a guy who's 22 with effectively no criminal history, these 2 arrests, one relates to being dumb and speeding away from the police, and the other is some mix up with a significant other that right now is dismissed, but the state could still decide to indict. That's a long time. Okay, what do you want to add about Mr. Carter?
Judge, he's 22. He was born in New Orleans. He grew up here in Atlanta. He does have his GED. He previously worked at a dealership, and then he was working and gainfully employed at a warehouse when he was arrested this most recent time. He's eager to get out and get his life back on track after this 419 days in custody, Judge. We would just ask that you accept the state's recommendation in this case.
Okay. Mr. Carter, how long were you out between the 2 jail times?
I was out about 4 months.
4 months, and then you got locked back up again. Okay. Why did you not want to pull over when the police blue lighted you in July of last year?
I'm not gonna say like I have a problem with I got a problem like schizophrenia, like light colors, like I get nauseous and start sweating. So I froze up and then I just got stiff and I just kept going. I didn't never look back. So I
Okay. Do you have you talked with a doctor about that condition to see if you can get any medicine?
I have not, but I had told the officer on that case about it, and he said that I had to go take that on my own manners and handle to go to the doctor and file that motion.
Okay. Got it. When you get out, which you will soon, where are you going to live? Are you going back to the Fairburn address that we've got for you, or somewhere else?
I am going back to the Fairburn address for like approximately about 4 to 3 months.
That's the Fieldstone Drive address?
Yes, sir. 165 Fieldstone Drive, Fairburn, Georgia.
Who stays there?
My caretaker.
Okay. And you said you'd be there for a few months, and then where would you go?
I will be getting back on my feet and finding my own places of residence.
Okay. Got it. Do you have any questions about anything we've discussed?
Yes, sir. I wanted to know, is that time served or like, is it time served or wouldn't that, like,
I haven't said yet. I'll let you know in just a second.
yes, sir.
Any other questions?
No, sir. That's it. That's it. That's all I have today for you.
Okay. All right. Well, Mr. Carter, I find there's a factual basis for your plea that in July of 2022, you did speed off when the police tried to stop you, and it was dangerous. It was reckless. I'm glad you didn't get hurt. I'm glad the officers didn't get hurt or any bystanders. I also find that your plea is knowing and voluntary. That just means you've understood what we talked about and that no one's forcing you to go forward with this plea, but it's something you want to do. Is that a fair statement?
Yes, sir.
Okay. I'll accept your plea to the reduced counts, the 2 misdemeanors. Ms. Wood, can we sign your name? Can my staff sign your name to the indictment?
Yes, Judge.
Ms. Clark?
Yes, Your Honor.
Mr. Carter, is it okay if we put your name on the indictment as well, indicating your misdemeanor plea?
Yes, sir.
Great, we'll do that. So what I'm going to do, Mr. Carter, is sentence you to, on count 1, which has been reduced to reckless driving, to 12 months to serve, but you're going to get credit for all the time you've been in, which is more than 12 months. And then count 2 is going to be 12 months of probation, 12 months of probation. And you're going to have 3 special conditions of probation. Number 1 is that you're going to meet with a doctor or a counselor and have a mental health evaluation. So that doctor can say, hey, you might want to take, not you might, you need to take this medication or that medication or go to counseling, whatever it is. And whatever treatment that doctor recommends, you need to follow while you're on probation, okay?
Yes,
That's
sir.
number 1. Number 2, you need to take that driver safety course, and you need to do that within the first 2 months, the first 60 days that you're out on probation. You find that class and you take it. And finally, number 3, you're going to do 50 hours of community service. You don't need to do that right away, but you're going to want to knock it out so it's not waiting for you a little ways down the road. Ms. Clark, did you have any other conditions of probation you wanted to see?
No, Your Honor.
Okay. And you know what? I'm going to waive your probation supervision fees, Mr. Carter, for the first 2 months. Just like you're trying to get back up on your feet, I don't want you having to pay those supervision fees for the first 2 months. But then you'll need to start paying them in month 3. Ms. Wood, anything else on behalf of Mr. Carter?
No, Your Honor. Thank you.
Mr. Carter, do you have any questions about anything I just said?
Yes, sir. I would like to ask you one more question. Is it okay if I get my discovery packet and the information about the probation office number and details?
Judge, I sent a packet to Cobb County. I'm not sure how long it takes to get there, but I do have a good contact number for him when he gets released. So, Mr. Carter, I will get all of that information to you.
Yeah, so it may be in the mail system there at the jail, Mr. Carter, but if I were you, I wouldn't wait around for it because you're going to be getting out today or tomorrow. Don't stick around just to get your discovery. Ms. Wood will connect with you and make sure you get all that. You're entitled to it, and I'm sure Ms. Wood will get it to you, okay?
Yes, sir.
Anything else?
No, sir, that would be all.
All right. You know, I don't know if you lose your license because of this. I don't do traffic court, so just be real smart. If you don't have a license, you shouldn't be driving. You figure out how to get your license back, whatever you need to do it by the book. Because if you get pulled over for running a stop sign or something, they're going to come down pretty hard if you don't have a driver's license. And judges aren't going to be real sympathetic, okay?
Yes, sir.
All right. Thank you, everyone.
Thank you, Judge.
Thank
All right. I think all we have left is Mr. Evans. Is that right? Let me look at the calendar. We mowed through that. Thank you, Ms. Clark, for those pleas. Oh, and Mr. Kennedy. I don't know if we're going to get Mr. Kennedy, TBD, but let's at least do Mr. Evans. Mr. Tolles, are you able to join us or are you in court right now?
Judge, I was listening in and I was driving because I got to get to Gwinnett County, so I'm gonna pull over real quick. But if the DA could call me while I'm doing that, I'd like to speak with her before we go into court.
Okay, well, why don't I have Ms. Clark step outside or into the jury room and give you a call? You have his number?
Yes, I have it, Your Honor.
Okay, great. You guys talk and I'll let Mr. Evans know. Hey, are you Mr. Evans?
Yes, sir.
Good morning. I'm Judge McBurney. Your lawyer, Mr. Tolles, needs to have a quick phone conversation with the prosecutor, Ms. Clark. So she is going to step outside the courtroom, call your lawyer, and we'll see if we can handle your probation revocation today, okay?
Okay, thank you.
So you stay right there. I don't think this will take very long.
All right, thank you.
Ms. Nelson, do you have any information about whether we're going to be able to get Mr. Kennedy in any booth? I'm going to mute Cobb. Okay. Poor Mr. Kennedy. Ms. Wood, Ms. Nelson is reaching out to our contact at the jail. They had said to close out all the booths because they thought we were done with inmates at Rice Street. But I don't think Mr. Kennedy had hit their radar because that was, as you know, a very late addition. So we're checking with them and we'll see what answer we get.
Thank you, Judge. I believe this one will work out today if we can get him in a booth.
Okay.
And so, I want to speak with the judge, of course, first, but I think we can, I think if the judge, doesn't oppose me, we should, okay, all right, thank you, all right.
Your Honor, could I have a brief breakout room with my client, Mr. Evans?
So it doesn't work that way at Cobb. If we can get the deputy and she's still available, you actually have to call a phone and speak with Mr. Evans that way. So I don't know if Mr. Evans wants to.
I think he'll be in agreement with the recommendation, so I think we're prepared to move forward.
Okay. Meaning you were ready to move forward right now?
Yes, I am.
Okay, let me unmute there. All right, Mr. Evans, can you hear us?
Yes, sir.
All right, let's go on the record in your case, which is 19 SC 170465. Mr. Evans is at the Cobb County Jail. Mr. Tolles is appearing, excuse me, virtually from the side of the road somewhere. We've got Ms. Clark here in court. Let me get your lawyer on the screen as well. There he is. Mr. Evans, you are here because I signed a warrant a couple months ago in your case, alleging that the allegation was that you violated your probation by committing a new offense of fleeing and attempting to elude the police, discharging a firearm near a public highway, reckless conduct, and reckless driving. This all allegedly happened on the 15th of February of 2023. Mr. Tolles, is Mr. Evans stipulating for the purposes of this revocation that he was arrested for those offenses on or around the 15th of February 2023?
Yes, he is, for the purposes of this hearing.
Okay. Do you know if those charges have resulted in an indictment or any formal accusation?
The last I checked a couple of days, Judge, they still had a CP number, so he has not been indicted and the charges have not been disposed of.
Okay. Is Mr. Evans still in custody in connection with those charges or just this warrant?
Just this warrant, Judge. He, when he was arrested for the CP case, he bonded out. His probation officer was informed of the arrest, and then subsequently they took out a warrant for him, and he's been in custody since.
Got it. It's really loud in booth one. Okay. What is your recommendation, Mr. Tolles, in light? Well, let me add a couple other things. Mr. Evans has just about 6 years left on his probation in this case. And he's had no revocations prior to this one in connection with this case. So that's where we are. What is it that you're recommending, Mr. Tolles?
Judge, because this is his first recommendation and because he has many, many years, I believe that this was just a situation where a learning experience for Mr. Evans. And I would ask the court to accept the recommendation of the state, which would be to release him on time served after serving 30 days and to reinstate him on probation. Obviously, we will have to come back and address the CP charges at a later date. And so he's not out of the water yet. But I would just ask that he has kids. He was trying to get back to those kids before the Christmas holidays. And so I would just ask the court that since he's been on probation for almost 4 or 5 years, and this is his first violation, and it's still not been adjudicated, I would ask the court to release him on 30 days to the Fulton County Jail and allow him to be reinstated on probation, and we'll deal with the felony charges at a later date.
Do you represent him in connection with those, Mr. Tolles?
Yes, I will be representing him.
Okay. Ms. Tucson, is Mr. Evans on probation anywhere else for anything else, or is this his one case?
I'm going to check that. I have his file right here. That's Lewis. This is the only one he is on probation for that's active.
Okay. And you see this as his only revocation so far?
That's correct.
Okay, got it. Ms. Clark, what's the state's recommendation?
Your Honor, in lieu of the fact that the defendant, well, first, the state's recommendation is to revoke 30 days and to reinstate. And our recommendation is because, in lieu of the fact that this is the first revocation for the defendant, and based on my communication with Attorney Tolles, his family ties, and the fact that he was employed prior to being arrested for the violation, the state is thinks it would be an appropriate sentence for the violation.
Okay. Wow. Oh, that's Ms. Tucson. Okay. Mr. Evans, anything you want to add?
No, sir.
Okay. Well, I will go along with the joint recommendation. I will revoke 30 days of your probation, reinstate the balance. Do you know who your probation officer is, or had you moved to non-reporting status?
Well, actually, my probation officer, like I have one month, and next month I have a new one, and I don't know the new probation officer.
Okay.
The phone call, like the non-reporting, I would just have to call.
When you get out, will you be returning to that Fennel Way address?
Yes, for the time being, but I'm in the process of moving, and I will let my probation officer know the new address.
Okay. Ms. Tucson, how should Mr. Evans plug back into probation when he gets out?
Right, because it might not stay on he might not stay on non-report. So, but he does have Officer Jefferson. So when you are released from custody, you know where probation is here, right, in Atlanta, 276 Memorial. You do know where it is?
Yes, ma'am.
Okay, just make sure you report and give them all your updated information. The address the judge just aforementioned, I do have that on file as well. So just make sure you do report when you're released so you do not get another warrant.
Yes, ma'am.
Any questions about that, Mr. Evans?
No, sir.
Okay. Well, that's what we'll do. Best of luck going forward. Thank you, Mr. Tolles, for patching in.
Thank you, Judge. Good to see you. Have a happy holiday.
You too.
Thank you. Oh, and thank you, Ms. Clark.
Yes, sir.
Thank you.
All right, thank y'all.
You bet. Can you have the deputy pop in?
Yes, sir.
Thanks.
You finished? So what happened?
Hey there. Thank you so much. I think we're done with everyone up there. I just appreciate you accommodating us, making that phone available and everything. Appreciate it.
Thank you, Your Honor.
All right. Have a good holiday.
You too, sir. Thank you.
Bye-bye.
Bye-bye, sir.
All right, Ms. Nelson, if you can hear me, we need Mr. Kennedy to go into a different booth because we removed 1 North Booth 1 from the session. We can't allow it back in. It was when you remove it, it's like a sanction. He could go to the one right next door. He could go to 1 North Booth 2. If he's on 1 North, any of those booths, we just need to know which booth on 1 North he's going to be in. I'm not able to add booth 1 back in.
Yes, Judge.
Oh, okay. I don't know who that was, but that was great.
Judge, try booth 2, please.
Okay. Ms. Wood, we've got Mr. Kennedy here.
Finally, thank you, Judge.
Well, thank you, jail, for making that happen. Let's add Ms. Clark as well. So before we get on the record, let me make sure I understand what we're doing. Mr. Kennedy has an unindicted matter that may well be something that Ms. Willingham would handle or someone in one of those specialized units. That's not gelling today. And so what Mr. Kennedy wants to do is enter a plea solely in this 18 SC case, which is super old, but Mr. Kennedy disappeared from us for a little while, and he got picked up on a failure to appear / bench warrant this year. And that's what he wants to do, or am I misunderstanding what we're doing?
Judge, that was my other client from yesterday, Mr. Peters.
Okay, I'm crossing wires. Mr. Kennedy just has one case. It's this case, and it's the only one he wants to resolve.
Yes, Judge.
Good. Didn't mean to make you panic, Mr. Kennedy. You don't have a new case. Ms. Wood was really trying to sort things out for a couple folks, and we went around and around. Mr. Peters is the gentleman in the wheelchair.
Yes, Judge.
Okay. All right. All right. So, Mr. Kennedy, all we're doing, as I understand it, is that you're going to attempt to tender a plea in your one case, which is a burglary from way back in 2018. Is that right?
Sir, yes, sir.
Okay. Then let's get on the record. It's 18 SC 163371. And before we can start the plea process, I need you to tell me that you are okay appearing from jail rather than being here in court. You have a right to be in open court, but you can waive that right and say, I'll be fine in booth 2 on the 1 North.
Yes, sir. I'm okay with booth 2, 1 North.
You also have a right to have Ms. Wood right next to you in that booth so you guys can speak privately, but she is where she is and you're in booth 2. Are you okay having Ms. Wood not right there at your side while we do this plea?
Yes, sir. Sir, yes, sir.
Okay. You just say yes. That's fine. Will you let me know if you ever feel like you need to speak privately with Ms. Wood?
Sir, yes, sir.
Okay. And if you've got any questions, will you let me know?
Sir, yes, sir.
All right, Ms. Clark. You're up. Oh, yes, Ms. Wood.
I'm sorry, before she starts, because there was a lot of back and forth yesterday, and I had presented to Mr. Kennedy a lot of different potentials for how this could go. And so I just wanted to let him know before, so he's not caught off guard. The state is agreeing to what we had asked for, which is the reduction, Mr. Kennedy. So we can go forward, Judge.
Okay, when you're ready, Ms. Clark.
Yes, Your Honor. I just want to pull his case up on Odyssey.
Sure.
One moment.
I'm going to do the same thing.
Okay, Your Honor, the state is ready. The state will be amending the charges in this case. For count one, for the record, will be for the burglary in first degree, the state will be amending count one to criminal trespass under 16(7)(21). And for count two, theft by taking felony, the state will be recommending, not recommending, the state will be amending this charge to theft by taking misdemeanor.
Okay, so it's a plea to 2 misdemeanors.
Yes, Your Honor.
Got
it. Defendant Kennedy, please raise your right hand. Do you swear or affirm that any evidence or testimony that you shall give in the matter currently pending before this court shall be the truth, the whole truth, and nothing but the truth under penalty of perjury?
Yes, ma'am.
You can put your hand down. Please state and spell your correct legal name.
Anthony Kennedy, ANTHONY, KENNEDY.
Are you at this time taking or under the influence of any medicine, drugs, or alcohol?
Yes.
Did you say yes?
Yes.
You're taking medication. What medicine are you taking?
I'm taking Depakote and I'm taking Dilan's. I have seizures. I have epilepsy. I have bad seizures.
Okay. When you take would you take those medicines in the morning or at night?
I take 750. I take 750 in the morning time and I take 750 at night.
Did you get 750 this morning?
Yes, sir.
When you take the medicine, does it make you drowsy or woozy or confused?
No, it helped me with my seizures. It just really helped me. It helped me calm. Like if I'm stressing or if I'm thinking about it a lot, I have a seizure. So they really it block it out. Like if I'm really stressing, it helped me not stress. It helped me want to clean up. Well, it don't have me confused or dizzy or anything like that.
Good.
It actually helped me.
It helps. Good. Okay. Thank you so much.
How old are you?
I'm 38.
What is the highest level of education you have completed?
If I'm not mistaken, 11th grade.
Are you able to read, write, and understand the English language?
Yes, ma'am.
Do you understand that you have been charged with the following offenses?
Yes, ma'am.
Count one, burglary in the first degree. The state will be amending this charge to criminal trespass. For count two, theft by taking felony, the state will be reducing this charge to theft by taking misdemeanor.
Yes, ma'am.
Do you understand that you have the right to plead either guilty or not guilty to these charges?
Yes, ma'am.
Do you understand that if you plead not guilty or remain silent, then the state is required to prove the charges against you at a jury trial?
Yes, ma'am.
Have you had an opportunity to review the indictment with your attorney?
Yes, ma'am.
And did you understand the indictment as explained to you by your attorney?
Yes, ma'am.
Have you had enough time to speak with your attorney about the indictment, including the facts and circumstances relating to these charges?
Yes, ma'am.
Are you satisfied with your attorney's services, Ms. Wood?
I sure am.
Do you waive a formal reading of the indictment for purposes of this plea? Oh, excuse me. I'm so sorry, Defendant Kennedy. Attorney Wood, do you waive a formal reading of the indictment for purposes of this plea?
We do.
Do you waive any defects in the indictment for purposes of this plea?
So waived.
Has your attorney advised you of the minimum and maximum sentence for each charge to which you're pleading guilty today?
Yes, ma'am.
The state will provide those for the record. For count one, criminal trespass, the minimum is 1 day in jail, the max is 12 months in jail. And for count two, theft by taking misdemeanor, the minimum is 1 day, the max is 12 months in jail. Do you understand that you are entering a negotiated plea of guilty, which means that the state and defense jointly will recommend the following sentence to the court? For count one, the state's recommendation is 12 months probation. For count 2, the state's recommendation is 12 months probation to run consecutive to count 1. The only special condition that the state is recommending is that the defendant stay away from the incident location.
Yes, ma'am.
Is that your understanding of the terms of the negotiated plea?
Yes, ma'am.
Do you understand that the court is not required to accept the state's recommended sentence?
Yes, ma'am.
Do you understand that the court has the right to sentence you to the maximum possible sentence on each charge?
Yes, ma'am.
Do you understand that if the court decides to order a sentence that differs from the negotiated plea you were expecting today, that you have the right to withdraw your plea of guilty?
Yes, ma'am.
Are you currently on probation or parole?
Yeah.
I didn't hear you.
I'm on probation.
Do you understand that if you're currently on probation or parole, your probation or parole may be revoked based on your entering a guilty plea today in this case?
Yes, ma'am.
Do you understand that if you're on probation, you must follow all the special conditions of your probation?
Yes, ma'am.
Do you understand that if you fail to follow all the special conditions of your probation, that you will be subject to revocation of that probation for the balance of your sentence? The special condition in this case is to remain away from the incident location of
45 Mount Perrin Drive in Atlanta.
Thank you, Your Honor.
He's got a question. What is your question, sir?
Okay, go back when she said it, I was on, she said if I'm already on probation and me coming, me getting this plea, I could be violating my other probation.
Well, maybe. It depends on how new your probation is. If you're on probation for something that happened after this situation, you can't get in trouble because this is old. Let me be real clear. This happened in September of 2018. This happened 5 years ago. So why don't you can help me answer your question. What are you on probation for now?
I'm on probation for now is aggravated assault and robbery.
Okay, in what county?
And DeKalb.
Okay, and when did you plead guilty or go to trial?
No, I plead guilty. Well, I plead guilty and not guilty. Is a word for it.
Right, an offered plea. But you did what you did. When did you do that? When you did your plea? When was that?
It was 3 months, man, like 3 months ago.
Okay.
I plead 15 through 4.
Got it.
I did 4 years and 7 years on probation.
Yep. So, Mr. Kennedy, this will not be a problem for you because this time when you broke into the guy's house on Mount Perrin Road or whatever happened before you pled guilty in DeKalb County. So Ms. Clark needed to tell you what she did, but if the only probation you're on is probation for something you pled to just a few months ago, this is not going to be a problem there, okay?
Okay, one more question. Clayton County, I have a hold for Clayton County. And I'm already on probation over there. I'm already on probation. And I know I violated that because I took the plea guilty in DeKalb County. But I have one open charge over there. When I leave here, I gotta go to Clayton County. So, okay. I'm just trying to make sure, well, if I go over there and see my probation, I talked to Mrs. Wood, and she said I have a month left to run out of my probation over there. And I know I'll be over there, like you have to sit over there. I've been over there before. So you gotta sit over there about 30, 45 days. And I know when I go to court, I terminate my probation because how long I've been locked up. So the charge is assault over there. And they offer me probation. If they offer me probation, but this happened
if I take probation over this, would that make me violate, would that be making me violate this?
No, because you aren't entering your plea till now. But I'll let Ms. Wood tell me if there's something you want to add. It's good that Mr. Kennedy is thinking through this. It's bad that he got in trouble in all these different places. But the sequence is the first thing that happened was this burglary. And you're not pleading to it till now, so you're not on probation till now. This plea can't be a problem for your DeKalb case because the conduct, the burglary, happened before your plea in the DeKalb case. Now, Ms. Wood, tell me, in Clayton County, Mr. Kennedy is both on probation and has open charges?
My understanding, Judge, is that it's a probation hold and it expires in January. So I'm not familiar with a new case in Clayton. I just know he does have to go to Clayton County to handle the probation that will expire next month.
Well, let's ask Ms. Tucson. Ms. Tucson, what do your records show about what's left on Mr. Kennedy's case in Clayton?
For Clayton County, he has 1 month and 9 days remaining.
Okay. All right. So
and, he has a DeKalb County case he's on probation for that ends in 10 years, 9 months, and 24 days.
Okay. Got it. Thank you.
No problem.
So, Mr. Kennedy, you heard that. You only have a month-ish left on your Clayton case. I don't know when you're going to get there, how long you're going to have to wait. They're going to close that one out. And this isn't the worst that could happen from this is that they'd say, oh, you have a new plea, but this conduct is older than your Clayton case, so they can't revoke you for it, if that makes sense.
Yeah, but not, yeah, but when they looked at it, they just said I had a new charge. I know about the probation, but they said I have an assault charge. But I'm just trying to what is the scenario when I do get over there, and if I do have the charge, and if I do take probation, would it violate my probation here?
It could. That's a decision for you to make in Clayton County. I don't know the specifics. Ms. Wood really can't give you advice on that. We're able to talk to you about things where you're already on probation. So you're going to get to Clayton and maybe you do have a new charge, and you're going to need to talk to the lawyer who's helping you with that new charge about what you ought to do and what its impact would be on your DeKalb case and on your Fulton case. Okay? Okay. Ms. Clark, let's keep going.
Yes, Your Honor. Are you a United States citizen?
Yes.
Do you understand that by entering a plea of guilty today, you're waiving all defenses, including any mental health defenses?
Yes.
Do you understand that by pleading guilty, you are giving up the following rights: the right to trial by jury, the right to remain silent, the right to confront witnesses against you, the right to subpoena witnesses on your behalf, the right to testify or offer other evidence, the right to the assistance of counsel, the right to the presumption of innocence, the right not to incriminate yourself, and the right to appeal if convicted of these charges at a trial? Defendant Kennedy, is it your decision to waive these rights, which means not to use them, and to enter a guilty plea today?
Yeah.
Has anyone forced, threatened, coerced, or promised you anything to get you to enter this guilty plea?
No.
Is it your decision to enter a guilty plea because you are in fact guilty?
Yes.
As to indictment number 18 SC 163371, how do you plead to count 1, criminal trespass?
Guilty.
How do you plead to count 2, theft by taking, misdemeanor?
Guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes.
Do you understand that you only have a limited right to appeal this guilty plea conviction?
Yes.
Do you understand that if you wish to file a direct appeal, you must do so within 30 days from today's date?
Yes.
Do you understand that if you wish to challenge the voluntariness of your guilty plea, you must do so by filing a habeas corpus petition?
Yes.
Do you understand that for a misdemeanor charge, you only have 12 months from today's date to file that petition?
Yes.
At this time, the state will provide a factual basis for the misdemeanor plea in this case. If this matter would have went to trial, the state would have been able to prove beyond a reasonable doubt that on September 28th of 2018, at the incident location of 45 Mount Perrin Road in Sandy Springs in Fulton County, officers responded to a burglary that occurred between 2:00 p.m. on 9/28/2018 and 11:27 a.m. on October 2nd, 2018. Officers spoke with the victim, Ms. Kelly Boudreaux, a realtor for the homeowner, who stated that an unknown person entered the home and took a LG washing machine, a LG dryer, and a Wolf range oven. Ms. Boudreaux and the homeowner, Pat Shannon, observed the forced entry into their home via a basement window. Using biochromatic fingerprint powder, crime scene technicians processed the window where entry was made. One lift card containing multiple friction ridge patterns was submitted to NGI to be searched. A preliminary identification was made on the latent print to the accused, the defendant in this case. The preliminary identification was peer-reviewed and verified. Mr. Shannon stated that no one by the name of Anthony Kennedy, the defendant, worked for him or worked on the home site while it was being built. Warrants were then taken out for the defendant for the crimes of burglary in the first degree and theft by taking, felony. Nothing further from the state, Your Honor.
What about restitution, Ms. Clark? Are we not pursuing it given the passage of time, or were these items recovered, or where are we?
Because of the passage of time, we are not pursuing it. And also, Your Honor, the state has made reasonable efforts to speak with the victim in this case. As I had indicated on yesterday, with this case, Attorney Wood had contacted me about this case previously, and the state has made reasonable efforts and have been unable to speak with the victim.
Got it. Okay. Well, and it looks like the house has changed hands. I mean, if it was on the market, it's not going to be the same people now anyway. Or it was being built, it's a different set of owners anyway. Okay, that's very helpful. Thank you. Ms. Jackson, criminal history information on Mr. Kennedy, please.
Yes, Your Honor. He has a total of 19 cycles. The last arrest was February the 12th, 2021 in DeKalb County for armed robbery. That charge was nullified on October the 7th, 2022. It does appear to have an outstanding hold out of Jonesboro, Georgia for a probation violation. The date on that warrant was July the 31st, 2018. He does have a prior felony conviction and a sentence. Sworn in 2012 out of Clayton County for terroristic threats act and aggravated assault. And he received first offender treatment in 2007 out of DeKalb County for possession of controlled substance and possession of marijuana with the intent to distribute. That case was sealed December the 5th, 2013. He does have misdemeanor convictions. Sworn in 2014 out of DeKalb County for battery, family violence. And there was one in 2009 out of DeKalb County for possession of marijuana less than an ounce. And one in 2008 out of DeKalb County for theft by taking. And there was one in 2006 for theft by taking / larceny. Nothing in addition. I do see 2 failure to appears. One in 2023 and one in 2018. Nothing in addition, Your Honor.
All right, thank you so much. All right, Ms. Wood.
Thank you, Judge. And I'm not sure, those two failures to appear may be the same issue. I'm trying to determine, it looks like the bench warrant from Judge Reeder may have not ever officially been signed or served from January of 2019. I was contacted by Mr. Kennedy's family and then also the attorneys that were working with him in DeKalb about that issue earlier this year because he was eager to get back over here and handle it. He was actually in the DeKalb County Jail from February 21st, 2021 until October 13th of this year. So he has completed 2 years and then he's been here since then. But Judge, he is 38 years old. He has 2 children, ages 8 and 18. He doesn't have his GED. He works in landscaping. He also does painting, other types of handyman work. He is eager to get out. I updated his address with the court. He's got a different location than he was staying at when he got involved in this situation in 2018. I've spoken to his mother. She's eager for him to return to live with her. She said it's in a better neighborhood and she's excited for his future. She thinks this will be a better opportunity for him. So we would just ask that you accept the state's recommendation, Judge.
Okay. So where does your mom live, Mr. Kennedy? I don't mean street address, but is it Atlanta or Fairburn or Lithonia?
It's Ellenwood, Georgia.
Okay. And are you comfortable living there?
Yeah, is where old people stay. It ain't where old young people stay. So I feel comfortable with the surrounding. There's no gangs, there's no young people, it's nothing I can get into.
Got it. Unless you get into it with old people over bingo or something. All right.
I got one question. I guess for Ms. Clark, I know y'all said 12 months on probation, and I'm willing to take everything. You know, I agree with everything, and I'm down with everything. But is it any type of way I probably could get 12 months community service? I would work it out. Besides probation, because I don't want to get over Clayton County, and if I do got something, got to take, if I do want to take it, I don't want to come back over here, because it's crazy. I'm trying to go home, and I promise you, y'all won't see me get less if I will work it off. I promise you. And because I don't want to come back in. You even put me on house arrest to make sure you could find my location, you could find me at whatever you need me to work it off. I will work it off for a whole year, 12 months. The same amount of time for the probation, I will work it off community service, whatever I need to be at.
All right. Hey, Mr. Kennedy, I'm going to pause you because Ms. Clark heard everything you said, but you don't negotiate with her. Your lawyer does, and I'm the one who's going to impose the sentence. So I hear you, and I can tell you're wrestling with this Clayton County situation. I don't know what's going on there. It's not going to be the probation piece. It'll be that new charge. I didn't hear anything from Ms. Jackson that there's a new charge there, but we'll see what happens. Here's what we're going to do. I find that there's a factual basis for your plea for this thing way back in 2018. I also find that your plea is knowing and voluntary, meaning you've understood what we're talking about. And when we didn't, you asked a question. You were very good at that. And it's voluntary. No one has forced you to do this. What I'm going to do, Mr. Kennedy, on count 1, which has been reduced to criminal trespass, is sentence you to 2 months to serve. You're going to get credit for the 69 days you've already served. So that's 2 months. Count 2 is going to be 12 months, but I'm going to probate those. So I'm going to put you on probation for 12 months. Condition number 1 of probation is stay away from 45 Mount Perrin Road. Condition number 2 is that you need to continue to take any medication that a doctor prescribes. So probation is going to say, are you taking your stuff for seizures? Are you taking your Depakote? Got to stay on the medication. And then condition number 3 in lieu of the other 12 months of probation is that you're going to have 120 hours of community service. So 2 months to serve on count one, but you've already done that. 12 months probation for count two. Stay away, take your meds, do your community service. That's it. You can do this, Mr. Kennedy. You'll be done with it. And hopefully you stop picking up cases like an armed robbery out of DeKalb, okay?
Sir, yes, sir.
All right. Ms. Wood, can we sign your name to the indictment?
Yes, please.
Ms. Clark?
Yes, sir.
All right, Mr. Kennedy, is it okay if we sign your name to this misdemeanor plea?
Sure.
All right.
Sir, yes, sir.
All right, Ms. Wood, you'll be getting the misdemeanor probation reporting instructions to Mr. Kennedy?
Yes, Judge.
All right. I think that's it. I want to thank everyone. Thank you, Ms. Alexander, for shuffling everyone around for us. Ms. Jackson, thank you for your help. We're probably done for the year with these calendars, so I won't see you till 2024, but I look forward to it. And thank you, Ms. Tucson. Your revocation notes that you give us in advance are super helpful, so that'll be an innovation we'll want to carry over into the new year. I wish everyone a safe and happy holiday. If you still have some holidays to celebrate, if you've already celebrated, hope that went well. And I will see some of you before the new year, but the rest of you sometime in January of 2024.
I want to say peace, love, and blessings. And Merry
You
Christmas.
too. Thank you.
All right. Thanks,
Thank you.
everyone.
Happy
Thank you,
holidays.
Judge.
All right. Bye-bye.
Bye.
Oh, Mr. Kennedy had to have some of that special time with us. That was nice.
He's cute.
All right. I think that's it.